Imagine getting paid just for sharing your thoughts on products and services you use every day. With Survey Junkie, it's that simple. Click on the link in the video description to discover how you can start earning today by taking surveys.
The jury tasked with deciding the fate of a former Jetstar pilot charged with killing two elderly campers have been told it's murder or acquittal. Lynn, 57, pleaded not guilty in the Supreme Court of Victoria to the murders of Russell Hill, 74, and Carol Clay, 73, in the Wanangata Valley, in the state's Alpine region on March 20, 2020. On Thursday, Justice Michael Croucher told jurors manslaughter was no longer a viable alternative charge due to the lack of evidence presented during the 5-week trial. The jury heard their decision now had to be a unanimous verdict of murder or acquittal. Manslaughter will no longer be available to you as an alternative charge in this trial, Justice Croucher said. Now that all of the evidence has been heard, counsel agree, and so do I, that if you were not satisfied beyond reasonable doubt of murder in each case, there would be no basis for an alternative verdict of guilty to manslaughter. Justice Croucher said if the jury could not be satisfied of a murder conviction, it could not convict on manslaughter. In those circumstances, any guilty verdict of manslaughter in the alternative would be wrong both in fact and as a matter of law, he said. Accordingly, you must put manslaughter out of your minds. Instead, the only charge before you is murder, and it's for you to determine. The jury heard the prosecution had provided no real evidence about how or why Lynn murdered Mr. Hill. The prosecution case concerning Mr. Hill is that in unknown circumstances, and by unknown means Mr. Lynn murdered Mr. Hill. The most the prosecution can say about the circumstances is that Mr. Hill and Mr. Lynn must have argued in some way, perhaps about the drone, Justice Croucher said. This led Mr. Lynn to murdering Mr. Hill in otherwise unknown circumstances by unknown means. The prosecution case concerning Ms. Clay is that in unknown circumstances, but in order to eliminate her as a witness to the murder of Mr. Hill, Mr. Lynn murdered Ms. Clay by shooting her to the head with his shotgun. The jury heard the Crown case hinged on Lynn's efforts to clean up the alleged crime scene proved he had committed the murders. If committed in the belief he had murdered Mr. Hill and Ms. Clay, its conduct the law calls incriminating conduct, Justice Croucher said. Turning to the defense case, Justice Croucher told the jury Lynn claimed Ms. Clay died as a result of an accidental shooting in the course of a struggle between himself and Mr. Hill. The defense case in regards to Mr. Hill is that he died as a result of an accidental stabbing in the course of his attack on Mr. Lynn. Justice Croucher explained to the jury that Lynn had maintained that version of events both during his record of interview and while in the witness box before them last week. The jury heard Lynn's barrister Dermot Dan, KC, claimed his client's account matched the evidence they had been presented at trial. In each case, submits Mr. Dan, Mr. Lynn's account in relation to the killings is consistent with numerous other items of evidence, including the fire evidence, the anthropological evidence, the insect evidence, the medical evidence, the phone tower evidence, the blood splatter evidence, the DNA evidence and the firearms evidence, Justice Croucher said. Justice Croucher said Mr. Dan claimed the jury needed to accept Lynn's account, accept it might be true or accept they can't agree beyond reasonable doubt he is guilty of the murders. Mr. Dan submits that other than Mr. Lynn's account and the evidence that supports it, there is a complete absence of evidence as to the means of which Mr. Hill died or as to the circumstances, he said. While we know Ms. Clay died as a result of a gunshot wound to the head, other than Mr. Lynn's account there is a complete lack of evidence as to the circumstances to which Ms. Clay died. In Mr. Dan's submission, the prosecution are effectively asking you to fill in the vast gaps in their case with speculation. In closing his case on Wednesday, Mr. Dan was scathing of the prosecution case.